Welcome to the Appellate Division First Department. We have almost 7.5 hours of argument time requested, so only ask for the time you need, not the time you want. We are familiar with the briefs and the records, and if we have additional questions, we will keep asking them. People versus Chance, appellant, submitted. Nuru versus WV Preservation, appellant. Is a respondent here? Do you wish to argue or do you wish to submit? I'll just give you 2 minutes, and if we need more time, we'll keep asking. Peter versus Fazika, submitted. Oval versus Church Street Construction, appellant. How much time are you requesting?
5.
Respondent? 5, 1, and 5. Palero versus Romero is submitted. People versus Morris is submitted, and the second People versus Morris is also submitted. ARC versus WWP is withdrawn. Marillo versus Downtown New York City Owners. Why don't we do appellant first? Were you the first appeal?
Yes.
Okay, I'm sorry.
5 minutes and 5 minutes.
Okay, second appellant?
For the plaintiff respondent appellant, 7 and 2, please.
For respondent, you were at 5 minutes.
Okay, I'm going to give you 5, 1, 5, 1, and 5, and if we need more time to ask more questions, we'll keep asking.
My appeal is that our function to her appeal? Can I have more than 1 minute?
No, if we have more questions, we'll keep asking them. People versus Harris is submitted. Emmanuel versus Evelyn is submitted. Gooda 26 versus Lightstone Acquisitions, appellant. Respondent. 6, 1, and 5. Brevitt Direct Lending versus Apprio LLP. Appellant.
5 and 2, please.
Respondent. 5, 2, and 5. People versus Brown is submitted. People versus Crony, appellant.
6 and 2, Your Honor.
Respondent. 6, 1, and 6. 413 East 187 Holdings versus NYC Department of Housing, appellant. I'll give you 3 minutes, and if we have more questions, we'll keep asking. Black versus City of New York, appellant.
6 and 2, Your Honor.
Respondent. 5, 1, and 5. People versus McGuire is submitted. People versus Cerillo, appellant. I'm sorry. Respondent.
7, please.
I'll give you 6, 1, and 6. Shanghai is submitted. Grace versus Sabal is submitted. Bay versus City of New York is submitted. And Manning versus Ramgopal is submitted. So our first case on today is Nuru versus WV Preservation.
Good afternoon, Your Honors. May it please the Court, Jared Kasanoff on behalf of appellants, both Richard Nuru and Marion Nuru. The only thing that Marion needed to establish below in order to demonstrate that she was a bona fide Mitchell-Lama tenant entitled to purchase the unit was that she would qualify for succession.
Well, let me ask you something, because her affidavit was somewhat vague as to specifics. Why, there could have just been an affidavit that said They resided there together for, a period of over 2 years. He left, she stayed, and she resided there the date of the eligibility plan. And there's no such affidavit in the record. How should we proceed with the absence of such a clear affidavit?
Yes, Your Honor, I was
It
not
sounds
the-
like she was being vague about exactly what did or did not happen, or what her position was or was not in this case.
I understand the concern, and I was not the attorney who argued this below. I admit that the record was less than articulate, but it was more than sufficient to establish the claims here. You have several instances in Marion's affidavit where she claims succession. You have paragraph 15 of Marion's affidavit in opposition to the summary judgment motion where she claims that she has succession rights. That's record page 283. You have paragraph 13 of Marion's affidavit in support.
But where does she claim that she resided there with him and that he then left? Does she ever say that?
By virtue of the fact that she's claiming succession, the elements of succession, there's two elements.
So you're saying she doesn't really need to say that specifically?
I think she does say it generally. She says that we've lived there as our family since the inception of the tenancy. There's instances in the affidavits where she says we've lived there for 28 years. And she says we, both me and her father. But notwithstanding that fact, yes, the fact that she claims succession, inherent as part of that claim, there's two elements. One is that she resided there as her primary residence, together with her father for either 2 years or for the inception of the tenancy, and two, that her father permanently vacated.
Okay,
Are
does
you saying
anyone have any?
necessary that she assert that?
Did she assert a succession?
Right, but I
asserts-
mean, that she assert the elements of it.
Is it specifically stated anywhere that she lived there for 2 years? It's not in an affidavit, but the record is replete with evidence in support of that. You have, first of all, she was 12 in 1992 when they moved into this apartment. You have the initial application for the apartment, which is in the record, which shows that her father, Richard, and her were the tenants. And it would be incredible to believe.
Wasn't she also on the income
She was on
affidavit for
almost
quite a
every
number of
single
years?
income affidavit since the inception of the tenancy. The record is replete with evidence showing that she lived there as her primary residence. You have both her driver's license, you have all her financial statements, you have voter registration records. It's clear that she lived there since the inception of the tenancy as her primary residence.
Thank you very much.
Thank you, Your Honors.
Oval versus Church Street Construction.
Please the court, Joshua Androphy, attorney for the appellants. The appellants should have been granted summary judgment in this action, dismissing the plaintiff, Mr. Ovalle's claims for arrest discrimination, overtime claims, as well as his wage notice and wage statement violations. To address the arrest discrimination cause of action first, the defendants here established through admissible evidence that Mr. Ovalle was not fired or otherwise subjected to adverse action due to his age or due to his arrest record, but rather he was terminated because of his substandard work and improper conduct
Counsel, the
towards...
termination letter does mention the felony assault, the crime, right?
It
So
does,
is
yes.
that not referencing his arrest?
It does reference his arrest, but the evidence... Well, two things on that. One, the evidence of his other conduct, his substandard work, his absences, as well as his harassment of employees, of verbal and physical abuse of
If they're
employees.
mixed reasons, is that, does the fact that there are other good reasons for terminating get you to a dismissal?
So I think in this mixed motive action, the plaintiff had to provide evidence that at least some reason offered by the defendants was either false, misleading, or incomplete. That's the standard under the mixed motive, under the Bennett action. And the reference to the arrest was not so much about the arrest itself, but the underlying conduct, which is not immunized just by the fact that Mr. Ovalle happened to be arrested and charged with a crime due to this physical altercation that occurred on site at the building that Mr. Ovalle was supposed to supervise. So he was the protection against discrimination due to arrest and criminal charges does not act to immunize any sort of completely inappropriate and unsafe behavior. There was ample evidence as well that the defendants continued to employ Mr. Ovalle for a full year from the time of his arrest. And not only that, but actually assisted him, paid for his attorney to defend those charges against him and successfully do so. And so the evidence does not permit a reasonable jury to conclude that his arrest was any part of the motivation. The clear timeline of
So the language in the letter of you have been charged with felony assault and a crime, you don't think creates a problem for your summary judgment motion?
I don't think a reasonable jury could conclude based on all the evidence that was even part of the motive due to the time, the assistance that they gave Mr. Ovalle, the continued employment, and all the other reasons which Mr. Ovalle, that the defendants had for terminating Mr. Ovalle. His egregious conduct on the job was the motivation for his termination. To address now also the overtime portion of the claims, the defendants here submitted the records that Mr. Ovalle himself filled out by hand each day that he worked, where he recorded his time, and those records show if he worked more than 40 hours in a week, he was paid overtime. This is not an employee who was never paid overtime. The pay records show that. Mr. Ovalle does not claim that these records are inaccurate in any way, that he was instructed not to record all his working time. He doesn't identify a single week within those records.
Weren't some of the records missing during that period of time, and weren't some of the records kind of illegible in the record?
Some records are certainly illegible, or at least difficult to read, just because of the photographing of them and the I guess brightness of them. The vast majority are there and are legible to the extent that one can see on those records the time that he wrote as his start time and end time. Some of the other notations there may be, admittedly difficult to read, but his actual hours
And
are.
I thought there were actually a couple months that were missing when we were
Right,
just looking at them.
Right, I do believe they begin from, I believe, February 2018. So it's not every single work week that he worked for the defendants.
But doesn't that defeat your showing of a prima facie case that you have not produced all of the time records?
I don't think it needs to, because the records that show the vast majority of the weeks, at very minimum, entitle defendants to at least partial summary judgment for those weeks or those months, and perhaps an exclusion could be made for any that are where there are not the actual written time records.
Thank you.
Good afternoon. May it please the court, Delmas Costin for plaintiff respondent. Your Honors, regarding
Let's suppose that the records were not that all of the records were illegible and that there were no missing records. In the face of that sort of documentary proof, is it sufficient for your client to just say, well, I recall working on weekends and going to a store before and after regular work hours to pick up supplies? Is that enough to defeat the summary judgment motion?
Your Honor, based on your hypothetical, yes, that would be sufficient. My client would have information. My client already has information to support his claim that he worked more than 40 hours in a course of a week. He has witnesses, he has text messages, so there's documentation, evidence to support that. So it's not just his own testimony saying, oh, this is what I did. He has objective evidence that he could submit. So that would be sufficient, Your Honor, in order to defeat the scenario that you provided. Your Honors, and I just want to say that regarding wages and hours cases, the employer has the responsibility of maintaining employment records for their employees. It's supposed to maintain documentation that shows the number of hours that were worked and a rate of pay. That information is missing here, and that is part of the reason, well, actually, that is the reason why defendants did not receive summary judgment. There are issues of fact that a jury needs to take a look at. And regarding, Your Honors, regarding notice and wage statements, if you take a look at the pay stubs, well, one, they're insufficient. There are only 14 provided, and I believe my client provided them. But also, Your Honors, in terms of the information that's on it, you're missing the number of hours worked and a rate of pay. So it's woefully insufficient under the law. And there's also, the defendants are also missing a statement, a notice, which provides information regarding the name of the employer, the telephone number of the employer, the hourly rate of pay. That's information that the employer is solely responsible for. It's not an issue of, well, my client didn't provide it in the case. No, the law makes it very clear the defendant's responsible, the employer's responsible for that. And just regarding the arrest matter.
Counsel, with regards to the arrest, how do you respond to your adversary's position that the fact of the arrest doesn't immunize your client from the underlying conduct of the arrest, and that your adversary it was permissible to consider that underlying conduct?
Because that's not the law, Your Honor. Under Bennett and Williams, those are First Department cases that clearly state discriminations play no role in determining an employment situation. So here, the employer specifically stated, because you were arrested.
Well, actually, they don't use the word arrest, but that's implied from you've been charged with a felony assault.
Yes, Your Honor. Furthermore, you're right. Furthermore, you have been charged with felony assault as a crime. So yes, you're correct. That is implied. But the bottom line is, the defendants told on themselves, right? When they put that in there, we have direct evidence that they're using an impermissible factor to make.
They were thinking of the arrest.
Excuse me?
That they were thinking of the arrest.
That they were thinking of the arrest, and that is why that's part of the reason why they terminated my client. And that is absolutely impermissible under the New York City human rights law, Your Honors.
Thank you.
Thank you.
Just briefly on the arrest issue, the cases that my adversary referred to are not, I don't believe, arrest discrimination or criminal charge discrimination cases, and the case law does not address the issue of whether underlying conduct that leads to arrest, if that is a partial basis for termination, whether that is considered a violation of the New York City human rights law and violates that discrimination. And that law should not be interpreted to give employees basically free rein to commit crimes in the workplace and not suffer any consequences with regards to their employment.
As to the overtime, why hasn't plaintiff succeeded in establishing that there's an issue of fact by his testimony that he recalls doing overtime work, and as counsel says that there are witnesses supporting that and text messages?
So plaintiff needs to show, for defense to be liable, they need to have either actual or constructive knowledge that Mr. Valle was performing this uncompensated work. And there was a system in place for Mr. Ovalle to report his hours, just like any other employee of the defendants. And if he's reporting 40 hours and being paid for those 40 hours, there's no constructive or actual knowledge on the part of defendants, and they could not be held liable. And when he did report more hours, he was paid accordingly, as the records show.
Thank you.
Thank you.
Marillo versus downtown NYC owner.
May it please the court, my name is Nicholas Avanti from Fabian and Coleman Hall, representing the defendant, appellant respondents. The lower court was incorrect in denying summary judgment on the contractual indemnity claims and granting the third-party defendant dismissal of those
Let me ask you a
claims.
question.
Yes, Your Honor.
The indemnity clause is a broad clause. It
Yes.
doesn't require negligence, but it does require arising out of the work. What significance should be given then to the fact that there was actually an exclusion in the contract for debris removal, and it's undisputed that this accident occurred in connection with debris removal and the lack thereof?
Well, it was connected to the tiles at the
I'm sorry, what?
it was in connection with the tiles that were being used. That the debris removal, even though that would be a rise to a duty, that would only apply on a negligence trigger. Just because there was a scope of duty that limited.
No. There was an exclusion for
Correct.
debris removal. So negligence, not negligence. I'm just talking about the question about arising out of.
Yes.
If their work clearly did not involve debris removal, it's pretty clear from the testimony and that exclusion that their work required working on the tiles, but it did not involve removing the debris after the tile work had been done, and this accident arose out of the removal of the debris. How does this arise out of their work?
Well, the plaintiff asked the workers for ERAF to put the tiles in the containers, which they did not do. They were the ones who put the tile on the floor. Plaintiff identified them as the workers who did that.
But ultimately, they weren't the ones that were supposed to remove the debris.
Correct.
They
But
might have created some of the mess, but their job was not to remove it.
it wasn't to remove it, but they created it, like you just said, which is a connection that arose out of their work. There's no, I'm not saying they were any kind of breach of a duty, just that was as a consequence of their work, the plaintiff was injured. That's the broad language from the arising out of provision of this contract. Unless there's any other specific questions, I believe that's the main focus of my argument.
Okay, thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Kristen Janaris for the plaintiff, Louis Marillo. Here, the defendants failed to conclusively establish the applicability of the integral to the work defense because although the plaintiff was generally responsible for clearing debris from the floor of the workplace, his testimony establishes that he was not engaged in that particular task at the time of the accident.
But isn't it, I'm sorry.
Go ahead.
But it seems to me of some interest that although he was at that point pushing a cart, he stopped at least at one time, bent over and picked up a piece of debris that was on the floor and put it into his cart. So it seems to me that he was continuing to remove debris while also moving the cart of debris. So it seems to me that undercuts your argument, doesn't it?
So what the plaintiff testified when he stepped on this piece of discarded tile stone was that he steps on it, injures his foot, looks at it, curses at it, and then throws it into the container. And I don't think that in that moment of responding to something in an obvious moment of frustration transforms his activity of transporting the carts into a cleaning activity.
Counsel, isn't it undisputed that the work that he was hired to do was debris removal, and he was the only one who was hired to do debris removal? There was no one else there doing debris removal. So since that's undisputed, how could it not have arisen or been integral to the work he was performing, which was debris removal?
Well, plaintiff testified and explained how this task was distinct from the act of cleaning. He testified that he was in the act of cleaning when he received a phone call from his foreman who told him to bring the carts down the freight elevator.
Why
and in
isn't
that
that
moment,
part of debris removal also? Why isn't, well, anything he was doing there had to be part of debris removal because his only function there was to do debris removal?
well, so I'd like to answer your question in two parts. First, the plaintiff testified that while he was responsible for cleaning work at the premises, he also had other responsibilities in line with a laborer at the premises. So he also did, for example, physically laborious tasks as climbing a ladder to remove sprinkler pipes from the ceiling. So at the very least, on this record, there's an issue of fact as to whether his conduct in transporting 12 carts in succession to the freight elevator to then be brought down to street level was part of that labor work.
Counsel, unlike the sprinkler example you gave, why isn't moving containers out part of debris removal? Because to remove debris, you don't only just pick it up, you put it in a container and you move it outside. That is all part of debris removal.
So the case law instructs that we scrutinize the task at hand at the time of the accident. And plaintiff's task at hand at that point was not picking up debris from the floor. He was doing something completely
Counsel,
distinct.
I don't understand why we're taking such a limited view, because if it's debris removal, it's putting it in the container and then getting rid of the container, right? You can't have 12 containers full of debris there and that's it, his task is complete.
Your Honor, respectfully, he testified that these were distinct activities that happened at separate times. The debris removal only happened once or twice a week and could only be done on the explicit instruction of the foreman because the dump truck had to be outside to accomplish the work. And plaintiff testified to the distinct nature as to these activities. He said when the foreman called him, he immediately stopped his cleaning work and stopped what he was doing to turn to the new task of transporting 12 carts.
So you're making a
succession.
distinction. You're making a distinction between cleaning, which is the actual picking up of the towel, putting it in whatever the bin, and then the removal, which is taking it to the dump truck.
Yes,
Or to the whatever.
I am drawing that distinction because construing the facts here in the light most favorable to the plaintiff, the summary judgment opponent, that is a distinct task. The act of transporting and physically moving these carts, which he likened to pushing a car, is very much distinct from the task of actually bending down to pick up debris and dispose of it.
What
And
case
this
supports
court's
such a narrow construction the way that you're trying to argue that? What case interprets it in the way you're arguing?
I was just about to turn to that. This court's decision in Prevost versus One City Block, I think, is analogous here because the plaintiff there was likewise responsible for removing debris from the work site. He tripped and fell on a loose piece of sprinkler pipe, and in that case, this court declined to apply the doctrine.
That case, it was undisputed that the pipe removal was not part of his work, and that the pipe was not debris, that it was actually going to be picked up by the pipe company. So it's completely distinguishable.
But nevertheless, the court in that case looked at the task at hand and found that because he wasn't in the act of cleaning at that point in time, the integral to the work defense would not apply, which
Thank you.
Thank you.
Thank you.
Good afternoon. May it please the court. Anthony Ruggieri from O'Connor Red Orlando. I represent Respondent ERATH in this matter. We believe the lower court respectfully properly dismissed both the third-party complaint and the complaint in this action. We believe that they correctly found that just because it was tile that the plaintiff alleged he tripped on, it did not arise out of ERATH's work. The scope that the third-party plaintiffs are seeking to assert against us is basically arguing that ERATH would be responsible for any incident ever that arises out of that tile.
Let me ask you something, because it is a very, very broad indemnification clause. There's no negligence trigger. It's arising out of the work. And one could certainly argue that this did arise out of the work because it was a tile that had been worked on by your client's company. So why didn't it arise out of their work, even if there was no negligence on their part?
So had ERATH been still on the floor, had ERATH still been working, had that tile been, shot from, say, they were chipping and the tile shot and hit the plaintiff, I would agree with you, it arises out of our work. But looking at it this way, theoretically—
It was debris that was left over as a result of their work.
It is also debris that, due to jurisdictional issues and unions, they cannot remove. So plaintiff, first and foremost, is the only person that supposedly told ERATH they had to put the debris in bins. He also said that debris all over the floor was commonplace. He testified that every trade left their debris everywhere. That was because of the jurisdictional issues, and basically laborers were the ones that had to be removing the debris. He doesn't have the power to create contractual duties or any duty really on the job site for ERATH. ERATH specifically excluded debris removal, whereas J.T. Megan's contract with the owner included it, that J.T. Megan was responsible for the removal of debris at this job site. With respect to plaintiff's claims, I would like to state that he actually testified that they removed debris from the floor and pushed the carts at the same time. Reading his
You're
testimony.
sort of saying it doesn't arise from Erat's work because it was the very work that J.P. Megan was supposed to be doing.
Correct. So once Erath left the floor and left the debris, and J.T. Megan's laborer came to do his only job that day on the second floor to clean the floor, that duty, the scope of work, Erath's scope of work ended, and J.T. Megan's scope of work began. If you continue to force Erath to be responsible for that tile, theoretically, say plaintiff made it down to the garbage truck, and that debris was being put into the truck, and a piece of debris fell out of the container while the container was being dumped, and that piece of debris struck the plaintiff. Would Erath be responsible for that simply because it was a piece of
So
debris?
once you finish putting the tiles on the floor, put whatever into the bins and your guys left, that was the end of the arising out of time for your work?
Correct. That is what we contracted to do, and that is what our scope
Would
of
it
work
have
was.
been different if he was picking up the debris while Erath was still working there?
If Erath's work in some way caused the tile to be, hit
No,
the
under
plaintiff.
normal circumstances. We're not talking about that you're chipping in and it flies and hits someone in the eye. I'm talking about just what happened here, except that the debris was being picked up as your men were still working, as your workers were still working, I should say, as opposed to like after the fact when they were done, when they were off the floor.
If the debris was not directly in the area where the Erath workers were working, then no, I do not believe that it arose in their scope because they had left the area at that point, in which case they don't have any obligation any longer to that debris.
Thank you.
Thank you.
The third-party defendant is saying that there was no obligation, we can't force the obligation onto them, but they took on the obligation when they decided to do it in rising hour trigger in the contract, not a negligent trigger. They could have chosen to have a more restrictive duty, but they went to a rising hour trigger. Unless the court has any other questions.
Thank you.
Thank you.
Your Honors, just briefly, the Court of Appeals in the Badgerick versus Alma case cited in our brief sets forth that there's two showings you need to make for the integral to the work defense, that it be inherent to the task at hand and not avoidable without obstructing the work or imperiling the worker. So even if this court were to find that this was somehow integral to the plaintiff's work, the second standard and element of this defense has never been established by defendants in this case. This was an easily avoidable premises defect, which could have been obviated or avoided by a simple measure such as putting an extra laborer on the second floor who could continuously pick up the debris on the floor while the plaintiff was engaged in the separate task of wheeling these 12 containers in succession to the freight elevators. So I would conclude with just saying that in any event, the defendants still have failed to conclusively establish, as in Badgerick, the applicability of this defense as a matter of law, and there was no basis to dismiss the complaint on this inapplicable defense.
Thank you.
Thank you.
Gooda 26 versus Lightstone Acquisitions.
Good afternoon, Your Honors. May it please the court. Jeffrey Ganjami for appellant. Your Honors, the trial court made several fundamental errors in deciding that the defendants never agreed to terms for plaintiffs to partner in the development of the Moxie Hotel.
Counsel, let me ask you something. We already heard this case before in the summary judgment, and we affirmed the denial of summary judgment in this case to both sides. The court below had a 5-day trial on a fairly narrow issue, which was whether there was an intent to be bound based on this email. And after listening to 5 days of trial, the court made credibility determinations and came to a credibility determination. Why should we, at this point, disturb that court's determination?
Thank you, Your Honor. Yes, the court made credibility determinations and determined that Mr. Talasasan was earnest and credible in his testimony.
What about about the fact that there was a lot of testimony below that the other side was not willing to enter an agreement until the stack was in place, the financing was in place, and the deal was closed? What was wrong with the court crediting that testimony and thereby finding that there was no intent to be bound on their side?
Okay, two points, Your Honor. One is that the one eyewitness to the offer and acceptance, the only eyewitness the defendants had was Mr. Milgram. Mr. Milgram, his testimony was based upon hearsay statements that Mr. Lichtenstein, one of his colleagues, said outside of the conference room. And in addition, Mr. Milgram was the one who told his general counsel at some point earlier in the case that that the terms were not voluntarily delivered to the plaintiffs on the day of the closing, that they were somehow surreptitiously stolen. And that was the position of the defendants early in the case. Then they just changed their whole factual narrative to say that the defendants voluntarily brought them. They prepared them to be talking about.
Yes, you have that point. Is that's the change in the story of how the plaintiff managed, how Mr. Talasazan managed to get a hold of this. But it's not like you have an email. This Landau email doesn't exactly have all the terms of a joint venture. I mean, what was the structure going to be of their joint venture? What was Talasazan paying for his interest in this joint venture? So when Supreme Court listens to all this testimony and comes to the conclusion that you don't have a binding joint venture, it's a pretty hard finding to set aside on appeal.
Your Honor, if I may, I don't believe the trial court actually found that term was missing. I think it's clear in the Landau email with the terms that it was a formula to be calculated, which was what was going to be the defendant's invested capital at the time of the construction loan closing. That was easily calculable. That all that needed to be done was at the time after they put in their money, they would say, this is what the amount that we put in, and they would have to pay the plaintiffs would have to pay 25% to have the shares conveyed to them.
Well, wasn't it a problem that this November 18th Landau email wasn't even sent to anybody on behalf of the plaintiffs? This is just an internal email, which in the subject line said JV, joint venture language, no signature lines, and I mean, it doesn't really look like a final agreement compared to, as the testimony was, so many other parts of the agreements that these parties had that were extensively papered and negotiated prior to that.
Your Honor, this is a very unique set of facts. In this signed purchase and sale agreement, there was a provision, Section 38, partnership agreement, that was a term, and it gave the defendants an extraordinary right to draft the terms in their sole discretion. It was up to them to figure out the method, the delivery, acceptance. This is what the defendants provided to Mr. Talasazan at the closing. It was completely up to them. Mr. Talasazan could either take it or leave it at that point. If he wanted to negotiate, he could have, but he didn't. He accepted the terms.
How do you address the statement in the court's decision that concerning subpart 6, stating that the interest shall have such other rights and obligations as shall be acceptable to seller and purchaser in their respective sole discretion? And the court goes on to say, an enforceable contract does not end with a statement that the parties will negotiate the rest of the contract in the future. Doesn't that establish that there are a lot of terms missing?
Your Honor, I believe that the material terms, if you scrutinize the document itself, it names the parties, what the plaintiffs were going to pay, when they were going to pay it, and the formula, and then it goes on to even additional terms, tag-along rights, drag-along rights, if there was a sale of the property, a sale of the company.
But it didn't specify the other rights and obligations that would be acceptable to seller and purchaser.
Yes, but not. I respectfully submit that the law provides that details of an agreement and non-material terms can be negotiated later. These were terms that were agreed to. Again, the defendants provided them. They had the right, the exclusive right, powerful right to do it their way. That's the way that they chose to do it. They drafted these. It should be construed against them, not against the plaintiffs. This is not something that what they're trying to do is
But they didn't draft it as a contract. They drafted it as an internal email. That's a very different thing than having drafted a contract and offering it to the other side and then for it to be construed against you.
Well,
They didn't draft it as a contract.
it was drafted as terms that were from PSA 30 from the purchase sale agreement section 38. That was the whole point. The parties agreed in the contract that they were going to negotiate terms and conditions of a partnership agreement. That's precisely what happened on November 19th. Is that they came.
Thank you.
Good afternoon, Your Honors. Jack Bowman on behalf of the respondent. The appeal here is simply a request for a different ruling on the same evidence. They are cherry-picking the evidence of the principal, ignoring the bad things he said, ignoring the things that my client said, and saying, we should win. The place for that argument is in the trial court. They made that argument to Justice Cohen. He sat through a 5-day trial. He observed the witnesses. He asked his own questions. He read all the documents.
Is the price easily ascertainable?
The price here? Absolutely not, Your Honor. It does not tell us what the price is going to be, what the consideration is for a joint venture of no extended term. It doesn't give us that at all. Also, importantly, one thing counsel said that I believe he's mistaken on, it does not identify the parties to this agreement. As Mr. Talasison said, who is going to be the party to this agreement? He said, well, it's going to have to be a new entity that I'm going to have to create. The party doesn't even exist. It's not identified in the document who the party to this agreement would be. Another thing that I want to emphasize is counsel said several times, Section 38 of the Purchase and Sale Agreement, that provision is irrelevant. It had a 75-day clock, and that provision expired in July. And that provision had no applicability to what happened on November 19th at all. It was not relevant to what was going on. There is no claim asserted in the case for breach of Section 38. They did not sue on that because it doesn't apply, so the reliance on it is inaccurate. The other thing that said that I just want to correct is just simply untrue that Mr. Milgram was the only witness to what happened. We had 3 live witnesses, Mr. Milgram, Mr. Landau himself, the author of the Landau email, testified at the trial, as did Mr. Teichman. So with those corrections, unless there are other questions, I would submit.
Thank you.
Quickly on those 3 points. Number one, the parties, the court made no ruling, as counsel just asserted, about the shares being conveyed. This was going to be at the construction loan closing. So whatever entities would have needed to be formed could have been formed, but it's clear that the plaintiffs were the ones that were at the closing. They're the ones who had the authority. There is no reason to accept the court's, to accept Mr. Bauman's argument when the court didn't accept it down below either. Section 38 did not expire in a sense because Mr. Milgram kept extending it. And the email the day before the November 19 meeting, there's an email from Mr. Milgram to Mr. Talasison where he's actually citing Section 38. He copies the whole entire 38, and he has it sent from Mr. Teichman's paralegal sends it, and he's copied on it. So here's the legal team of Lightstone sending that Section 38. So if it really expired, why are they acknowledging it the day before the closing?
Thank you. Brevitt Direct Lending versus Apprio LLP.
Good afternoon. May it please the court. My name is David Bain, and I'm here for the appellant. This appeal presents 2 questions of remedies. 1, how to calculate damages in a case such as this, and 2, whether Brevitt is entitled to prejudgment interest, even if it did recover all of its losses prior to trial. The trial court found against Brevitt on both issues, and we respectfully submit that where there's an injury, there should be a remedy. And we ask this court to reverse the court below.
To the first issue, which I guess you're talking about, what is the actual amount of damages putting aside interest, correct?
Yes, Your Honor.
So as to that issue, didn't we already affirm the part of the decision already which held that the damages was limited to $13.45 million in our prior determination?
We don't believe so, Your Honor. That portion of the trial court's decision we believe was dicta, and the appellate division didn't rule on that. The issue on the prior appeal was an issue of the standard of negligence. What was the duty owed by Apprio to Brevitt? And that's what the court ruled on. The court did not rule on damages, and I believe it has a footnote expressly saying that it wasn't going to rule on the damage issue.
Counsel, even if you were correct that we didn't rule on it, which I am not saying that you are, isn't that a well-established principle that on a tort claim, as opposed to a contract claim, you only get to recover, on a contract claim, the amount to be made whole? And to be made whole, that's the amount of the loan.
Well, that's where we disagree, Your Honor, because here we have a very interesting set of circumstances.
Putting aside the interest issue.
Well, Your Honor, what we're arguing is that the calculation here that the trial court did was incorrect, in that because there was 3.5 years of part performance of this loan after the act of negligence and prior to closing, or before the closing, excuse me, the court should take the parties as they find them. BHSC, the counterparty, the borrower, paid $4.5 million on this loan during the course of its, while the parties were performing it until 2020.
The loan was always intended to be $13.45 million. So to the extent that there was some negligence involved in terms of assessing it, that was the scope of the damages that could be incurred.
But, Your Honor,
as opposed to the interest issue.
Well, but, Your Honor, the way this loan actually proceeded is the parties proceeded with the loan despite knowing of the negligent act and tried to make the best of it. And as a result, BHSC made $4.5 million worth of payments, but the missed interest was recapitalized into principal. And so at the time BHSC abandoned the loan and stopped making payments altogether, the principal that was due was over $15 million. So in this case,
Let me ask you a separate
the trial court's decision really ignores the reality of what happened here.
Let me ask you a separate question, which is the second question about trying to recover on the interest. Why isn't your argument precluded by our decision in MUFG?
Because, Your Honors, I don't believe you reached the issue of interest on the prior decision.
Didn't we say in that case that the trial court properly applied the settlement offset before calculating prejudgment interest? And if you do that in this case, apply the settlement offset, which was the whole amount of the loan, before calculating prejudgment interest, there's nothing to calculate.
Well, but Your Honor, here there's excuse me, I'm sorry. Here there's clearly a loss here. It took 6 years for Brevitt to recover its money from BHSC. And there's no dispute that prejudgment interest on that amount would be $4 million. So here...
Right, but only if you're entitled to prejudgment interest, and why doesn't MUFG preclude that?
Well, MUFG, Your Honor, that case really doesn't apply here. We believe the New York State Thruway Authority and the Gottwald versus Siebert and the Century Indemnity case, and the two appellate division cases are applicable.
Why doesn't MUFG apply? On its face, based on the language I quoted to you, why doesn't that reasoning apply here?
Because MUFG, it's not really clear what happened. The court's decision is very short and not very robust, and the
Many of
appellate
our
record is
decisions
sealed.
here can sometimes
Well,
be.
I understand, Your Honor, but in that case, the court really seemed to be trying to avoid a duplicative recovery of having the plaintiff recover prejudgment interest on settlement payments that had previously received.
What about the language that I quoted to you, which seems to apply perfectly to this case, that the trial court properly applied the settlement offset before calculating prejudgment interest? Why doesn't that language by its plain terms apply to this case?
But, Your Honor, the trial court in its decision below also seemed to draw a distinction between contract and tort cases and suggested that if this were a contract case, Brevitt would be entitled to its prejudgment interest.
It's not a borrower situation. It's not where you lent money. It's a borrower-lender relationship. It's a tort claim.
But
it's
CPLR,
different.
CPLR 5001 doesn't recognize a distinction between contract and tort cases, and here Brevitt clearly suffered a loss of over $4 million in prejudgment interest for which it was never compensated.
You have time
Thank you,
for
Your Honor.
rebuttal.
Good afternoon, Your Honors. May it please the court, Matthew Ferlazzo on behalf of Respondent Apprio. As the court pointed out, there's two questions in the case, the lost principal issue and the recovery of prejudgment interest.
Is your position that we did or did not address the issue in our prior decision about what the amount is that's recovered?
I think, Your Honor, the appellant is foreclosed from raising it now because they could have raised it on the prior appeal and did not. On the prior appeal, the order at issue, the October 2023 order, addressed a number of issues, including issues as to damages, and the judge made particular rulings on those damages. Brevitt filed a notice of appeal, perfected that appeal. They argued certain issues, but as to the damages issue, the only issue they raised was regarding prejudgment interest. They did.
Are you saying it became law of the case because it wasn't part of the appeal?
Essentially, it did, Your Honor. They don't get to take another bite at the apple now on a subsequent.
Nothing in our decision disturbed the original determination?
Exactly, Your Honor. The court affirmed the lower court's decision. The opportunity was there for Brevitt to raise issues if they had an issue with the way the lower court had ruled with respect to the calculation of damages. Brevitt did not raise that. You cannot bring it up then on a subsequent
What about
appeal.
on the merits? Why is that determination correct about how the damages were calculated?
So with respect to the damage calculation on the merits, Your Honor, the issue is that in this case, Brevitt's but-for theory of causation is that they never made the loan. Under that but-for theory of causation, the only damages they can get are what they actually advanced on the loan. That's $13.45 million. They have now received more than that, and they cannot try to have that but-for causation theory and at the same time try to apply the funds that they received as though they did actually make the loan. Because their theory here, remember, is they didn't make the loan. So those funds coming back to them have to be applied, as the trial court said, to reduce the principal. And once that's done, since they received more than the $13.45 million, they received approximately $15 million.
And what about counsel's argument that there shouldn't be a distinction in the way interest is calculated on a contract case versus a tort case?
I think that isn't necessarily the right argument or the right approach. It's not, the question here isn't a distinction between contract versus tort. The question is the statutory language. The statute controls here. There's no independent right to interest. It's a creature of statute. The statutory language says it has to be upon an amount awarded. There can be no amount awarded here because when you properly apply the offset as per MUFG, which was taking breach of contract settlement and applying an offset to a tort damages situation, you then have to...
Yes, they got back their money, but they didn't get it back when they were supposed to. And there is a value to money at a certain time. They are losing those funds.
There is a value to money, Your Honor. There can be no dispute about that. But the way the statute is written, to get back that time value of money, they have to have a sum that's awarded. They're not going to have that here because the sum awarded has to be calculated based on what are the damages less the set-off. That leaves them with no damages. There's no sum awarded on which then to calculate the interest.
What about counsel's argument that MUFG doesn't apply in other cases that he cites in his brief? Are the applicable standard to be applied here?
I submit respectfully, Your Honor, MUFG does apply because it is from this court. It is addressing a situation where you're taking a breach of contract settlement and applying it to a tort situation and reducing the damages in the tort based on that breach of contract settlement. The third department decision regarding the New York Thruway case involved a contract where, involved a tort where the party admitted during the course of litigation that it should have paid the money. In this case, it is not Apprio. It has not admitted any sort of liability. We were not in control of the funds that they were trying to get back. So that makes it different than the throughway case. The Gottwald v. Siebert, again, is a similar situation where the defendant in that particular case made a payment to try to reduce its admitted liability, and so therefore there was nothing left based on that defendant's conduct. If the court has no other questions, thank you, Your Honors.
Briefly, Your Honor, with respect to the prejudgment interest question, the trial court ruled it in a footnote that the question hadn't been waived by the prior or addressed in the prior opinions and hadn't been waived. That's the footnote on page R8. With respect,
Yeah, we were asking about the damage question, the first question, not the second question.
okay, all right, I just wanted to be clear. With respect to the but-for issue that you raised a moment ago, we believe the proper but-for analysis is but-for Apprio's negligence, BHHC wouldn't have stopped paying its loan in 2020. And therefore, we have to look at what happened in that intervening time between 2016 and 2020. Otherwise, what happens is that Apprio actually gets the benefit of the party's part performance by achieving the $4.5 million to reduce its damages, but none of the consequences. Why does that only go one way? We submit it should go two ways, that if Apprio is going to take $4.5 million off its judgment, then off the judgment that we obtain, then the principal should be increased by the pursuant to the terms of the loan, because no one disputes that Brevitt was entitled to apply that $4.5 million pursuant to the terms of the loan. With respect to a sum awarded, the jury could reach a verdict to what the full amount of the damages was and the dates of repayment by BHSC, from which prejudgment interest could then be calculated on for the period of time that the money was outstanding. We're not trying to get interest on settlement payments that were already made, such as happened in MUFG and some of the other cases, most of the other cases upon which Apprio is relying. We're trying to get compensation for a period of time when we didn't have the money that we loaned. And that's the business that lenders are in, to make loans and to receive interest or some sort of compensation for the time value of their money. And that's missing here. So if, I think unless the court has any further questions, I'm done.
Thank you.
Thank you.
Just in time. People versus Crony.
Good afternoon, Your Honors. May it please the Court. Cara Labini from the Center for Appellate Litigation for Appellant Norman Crony. The lower court erred in denying Mr. Crony's 447 motion for Domestic Violence Survivors Justice Act resentencing for primarily two reasons. One, because the lower court found that the abuse was not a significant contributing factor to the offense.
But isn't there a temporal situation there that if the abuse was not continuing to be ongoing at the time that the act was committed, and then he doesn't get the benefit of that statute? That's how I understand it. Am I wrong?
Sure. So applications for resentencing to get a hearing need only show that the applicant was a victim of abuse at the time of the offense. This court in Williams interpreted that as including abuse or the abusive relationship need be ongoing. So that is the second reason the lower court erred in denying the application for resentencing.
Right, but he had moved out sometime before. So I don't think it just means that the parents were still the parents or the step-parents were still the parents. I think it means more than that, or that it would always be ongoing.
Well, so the
There has to be
corroboration.
some abuse of something going on
So
at
the
the time of the offense.
So first, Mr. Crony corroborated and alleged that he was a victim of abuse by his foster parents for his entire life, from the time
Right,
he
but
was...
he had moved out sometime before the actual incident. So he was no longer living in the home where the abuse took place.
There was also a domestic incident report indicating that he was visiting them.
And how long before this incident was?
9 to 10 months before the offense. I'm not arguing that this is the same case where a romantic partnership between two adults break up, don't visit each other
Right,
within
but
a year.
Williams already set up the parameters, because that was a similar case, it wasn't a romantic relationship. It set up the parameters that there has to be a temporal requirement that's satisfied. It can't be that you had abuse by your parents all through your childhood, and that is enough to trigger the
Exactly. But
So-
Mr. Crony alleged and corroborated an ongoing abusive relationship with his foster parents. The DIR showed that
He
he was
says he
in,
moved out 3 years ago, and then one incident happened.
but they were still in an ongoing relationship very close in time to the offense.
I mean, that they were still his is that the allegation?
Yes, and the relationship, the abuse in the relationship, Mr. Crony certainly corroborated, if not proved, was endemic to the parent-child relationship, not episodic. This was not something that happened once in a while. This was throughout the entire 13 years that he lived there. Under Williams,
Well,
that's
true. It's throughout the 13 years that he lived there, right? But there was, if I understood the record correctly, he had moved out 3 years prior to the incident, and then the domestic incident report that you're referring to, about a year, right? 9 to 10 months. Under your understanding, I guess the abuse never ceases then. Even if he was to never meet, even if he was to never see his parents or engage them again, the abuse, would it ever end?
No, that's certainly not my position either. My position is that there is an abusive relationship where abuse occurs, and the subject of the hearing should be whether the abuse is recent enough to have an impact on the applicant's conduct at the time of the offense. The closeness.
Williams required time of the offense. So you're just arguing we should have a very expansive interpretation of our prior decision in Williams about what time of the offense means?
No, Your Honor, expansive definition of abuse or abusive relationship. So,
Because if your parents abuse you and you move out when you're 18 and you commit a crime when you're 21, but they're still your parents, then under your definition, that would still be a continuing relationship.
I would say that's a little more simplistic than what I'm arguing, which is that the
I'm not
abuse.
understanding you.
I'm sorry?
I'm not understanding you right
Sure, I'm sorry. That the abuse continued throughout the relationship. Mr. Crony was still in the relationship with his parents at the time of the offense. Because Williams includes an ongoing abusive relationship.
So what you're saying is that it would never end because they would always always be his parents or his foster parents. I mean, that's not going to end. That's just a fact.
Just to piggyback on that, you said a moment ago that abuse was endemic to the relationship. So if abuse is endemic to the relationship, as long as the relationship is going on in any way, then the abuse, by your definition, is continuing, right?
No, I think that this is all, nailing down the exact timeline of whether an interaction was abusive, including psychological abuse, which the DVSJ clearly provides for, is the subject of a hearing. To require the parties to establish this fine, factual matter on the papers is too high an evidentiary burden for a motion for resentencing.
Thank you.
Thank you.
Your Honors, good afternoon, and may it please the court. Russell Spivak for the people. Defendant seeks to appeal.
So under what circumstances is it necessary to have a hearing and that you couldn't decide this on the papers, but you need to have a hearing? I mean, I'm confused about that. What's your understanding?
I would say
After Williams.
Under Williams, the statute holds that on the papers, it can still be established, absent a hearing, the temporal connection, whereas as Justice Farber held below, the hearing establishes whether the conduct is in fact rises to the level of abuse, or if it might just be sort of manipulation or something that would be labeled less than abuse, and whether or not the course of conduct, that is to say the criminal action, was under the present influence of that abuse. But
does nexus of the victim fall into any consideration here?
I don't believe that finds its way into the statute at the pre-hearing stage, Your Honor.
And the distinction you're now trying to draw between abusive and manipulative seems to me the kind of thing that would be much better determined at a hearing than on papers.
Absolutely, Your Honor.
So that if there's a showing of manipulation, that should be sufficient to grant a hearing.
So I apologize if I wasn't clear. The question of manipulation or abuse is squarely the subject of a hearing. The question of a temporal connection between what occurred and the abusive or ongoing relationship can be established on the papers. Justice Farber held that below. He was assuming, for the sake of his analysis, that the conduct was in fact abusive.
So, assuming that the DIR was about 9 or 10 months before the incident, why isn't that at the time of? Do you have how do you define the temporal limit of at the time of?
So the statute doesn't define the temporal limit. I understand that, of course. But what I would say is, going back to the point that this court had made previously, the defendant had moved out. He had effectively severed his relationship. And in the first affidavit that counsel had submitted, it says that the abusive relationship ended, the term ended, because the abuse occurred until the defendant had moved out.
But why at the, if it's the question, one issue is whether it's a subjective or an objective standard. If it's a subjective standard, then whether or not he moved out is not the only consideration, but how he's still experiencing it psychologically. And is there anything in either Williams or the statute that would shed any light on that?
There isn't, but by the very terms of the defendant's affidavit, it's the case that he sought to avoid any relationship or any contact with his purportedly abusive parents.
He did, right? So if you're looking at the time that he moved out, that was about 3 years before the incident, right? But if you look at the domestic incident report, if I'm correct, that relates to when he went back to visit his siblings, and then there's an allegation that the stepfather engaged in the same abusive conduct, sex abuse, that he had engaged before. That is much closer in time. That is not 3 years removed. That is 9 months removed. So why is that not close enough?
My understanding from the nature of what originally animated this statute is that it's particularly based on acting under present influence. There is supposed to be at least close in time, and it is certainly the case that the individual
How do you define that? What's your definition of close in time? How would you have us define that?
I think the answer would be that it would have to be...
Clearly you have a stronger case if it's 3 years.
Of course, Your Honor.
9 months, not so much.
Understood that for the sake of our case, it would be better if it were multiple years, if there was no contact, for sure. But when you have... This individual had only been, under legal definition, an adult for several years. He has plenty of time to have removed himself, to have severed that relationship.
Becoming an adult doesn't do away with the harms of sexual abuse, right?
Understood, of course. But what I mean to say in that is he has effectively severed that relationship. Maybe that might not have been the case if it were 2 weeks out or if it were 4 weeks out. But to hold that it's nearly a year prior to when the underlying incident occurred suggests to me that whatever episodic abuse might have occurred, and for sake of this analysis, we can assume it was abuse, understood, but whatever that might have occurred, it has certainly long since transpired. The defendant certainly could have and indeed would have moved on and no longer continued to have any
So without giving me a direct answer, you're saying 9 months is not the answer?
I don't think that we need to establish a distinct answer, Your Honor, but I think that 9 months is too much, correct?
Thank you.
Thank you, Your Honor.
Not only do we have the DIR, we also have the prison records. The prosecutor argued that the relationship couldn't have been abusive because prison records demonstrated that Mr. Crony was in a relationship with his abusive foster father when he was incarcerated. So not only do we have the DIR before the offense, we also have prison records after the offense showing that they were still in a relationship. As to the evidentiary standard, I just want to spend a moment. The standard that applies at a 440-47 hearing for resentencing is a preponderance of the evidence. The papers must have a lower evidentiary standard in order to even get to a hearing. Respondent argues that the fact that Williams is a post-hearing decision matters not at all in this case, but if that was true, there would be no reason to hold hearings at all on the question of whether the defendant was a victim of domestic violence at the time of the offense, which is, under 6012, the statute that governs hearings, the question at a hearing. So I think while there is not a, in case law or statutory evidentiary burden set out, it has to be something less than a preponderance, and Mr. Crony amply satisfied it.
Thank you.
Thank you.
413 East 187 Holdings versus NYC Department of Housing. So, council appeared shortly after the calendar was called, and what I'm going to do is give each side 3 minutes.
Okay, can I have rebuttal then?
Sure, so I'll do 3-3-1.
Okay, thank you so much. Thank you.
And again, if we have more questions, we'll
Okay, great. Thank you.
keep asking them.
Good afternoon, Your Honors. May it please the court. Diana Lawless, the attorney for HPD. The court here should have denied the petition.
Counsel,
Sure.
in your brief, you say that plaintiff forfeited its eligibility for tax benefits.
Right.
Are you saying it forfeited its eligibility when it rented the apartments without a C of O?
Yes, because it didn't apply with all the regulation.
So, but it seems to me that most buildings that get J51 benefits at some point were not entirely legal or were in violation of various aspects of the code. So how does the illegal use of the building at any time preclude benefits?
No, it's the illegal use of the building here. It's for during the time.
I understand, but what is your standard? How long ago, if the building was used illegally 5 years before it submitted its application for J51 benefits, would that also have forfeited their eligibility for tax benefits for all time?
It's for this is for J51 benefits are tied to a certain rehabilitation project. These people were undisputedly living illegally in the building.
The time they apply, was there a CO for the building?
The time they applied, there was a C of O on the building.
So are they getting retroactive benefits if they get this J51?
I don't think it's a retroactive benefit. I think it's a tax exemption for a specific period of time going forward, right?
So at the time they apply, they're in compliance.
Well, it says at the time they apply, they have to comply with all applicable laws, which include the building code, the MDL, the building code.
They had a CO. Is there something else that they were supposed to comply with at the time they applied?
At the time they applied, they had to show that they are complied with.
So you're saying the fact that they had rented out some apartments before the C of O makes them forever not able to apply because they weren't in compliance with all the laws that they were required to be in compliance with?
Well, the benefits are tied to a rehabilitation project, right? So like you get the benefits for the construction project that you undertook. They did have to provide their rent rolls, right? That's something that's a requirement of the application. They provided the rent rolls. They provided who was living there at what date. We reviewed under our regulation, under the statute.
Let me ask you about that, because you're relying on your regulation.
Right.
But obviously, your regulation can't do any more than what the administrative code provides. And I'm looking at the language of the administrative code, which says for a building to be eligible, it must comply with all applicable provisions of law as determined by the Department of Buildings, which certification shall be evidenced by certificate describing property involved. So here, at the time that the building applied, it did comply with all applicable provisions of law as determined by the Department of Buildings, because the Department of Buildings gave it a certificate of occupancy. So how can you have a regulation which requires more than what the administrative code provides?
I know there are times that I'll just like to say, and I think this is all throughout our brief, I don't think that they've ever actually argued that the regulation goes beyond what the statute allows. I think they're unhappy with our interpretation of it. But I think that as we explained in our brief, it's broad, and it would run counter to this entire goal, which is to have creative, safe housing, which is all throughout our brief.
But why isn't it at the time that they applied for the benefits, and there was already undisputed that they had a certificate of occupancy at that time, why weren't they in compliance with having a safe building as determined by the Department of Buildings?
I think it's also because we review the project, right? Review how they review the project. We reviewed the project.
So your position is that because they had tenants living there without a C of O during the project, that makes them ineligible?
Yes.
But there's nothing in the regulation that says in order to apply, the applicant must have been in compliance with all rules and regulations from the commencement of the work related to this exemption. it would have been easy enough to write it that way, but it wasn't written that way. So how can you now say it should be, essentially, there should be a look-back period?
Well, I don't think well, I mean, I don't know that I think there is I think that we review the project, so I think they know what they're submitting.
But what in writing says that you get to look back? I mean, Justice Kern read you the relevant provision, which says very clearly at the time of application, they have to be all legal. What in the regulations allows you to look back in time and say they have to have also been legal at every moment since they began the project that's going to lead to the exemption?
Well, I think that the regulation says the alteration work has been completed substantially. That the building has to comply with all applicable laws, including the building code, the MDL, and the housing maintenance code.
Right, but they did that at the time of the application. So what allows you to look at the time of application to whether they complied with all laws at all other times at which they were doing the relevant work?
I think as we're reading it, that there had to have been, they had to.
I know you're reading it that way. I'm trying to figure out what the words are that you're reading that way.
Well, I think the words that I'm reading that way are that the building code, the MDL, the housing maintenance code, the city charter prevent residential occupancy without a C of O. So that's why we read it that way, and I think that's in line with the entire statutory scheme, which was designed to create safe housing. And I also just point out one more thing, that the RTPL itself, I know they try to read and get into this, they try to read the provision to say, well, this whole unless and until language, that statute says that you may, unless and until, you may grant the benefits only unless or until compliance is achieved. They read out a different provision, which is 489.15, which is that the local law may restrict, limit, or condition the eligibility, the scope, or the amount of benefits in any manner.
Thank you.
May it please the court. Jason Frosch for the respondent. Your Honor's questions are all pointed at what allows HPD to do this, and they have admitted over and over again in their papers that they cannot provide any authority whatsoever for making a distinction between violations at a building, which is ubiquitous amongst J51 buildings, since that's the whole point of the program, is to take substandard buildings that don't comply with the law and incentivize a developer to bring them into compliance, where they can make a distinction between those types of violations and violations that occur during the project that rehabilitates the building. There are no such local laws. There's nothing in the statute. There's nothing in any prior determination by a court. HPD doesn't even provide any prior determination on an application for the benefits program that states that clearly or at all. And it doesn't even make any sense because in construction projects, it is par for the course that there will be some sort of violation during the process. A subcontractor might do something wrong. DOB comes, inspects, issues a violation.
That's different, however, than you taking on tenants without a C of O.
It's absolutely different.
That's not a mistake, right? When you take on tenants without a C of O.
It's absolutely different. And certainly if HPD had the authority to police the morality of the situation, they might make a distinction between an owner intentionally doing something, not to say there's evidence in the record of intention, but certainly they could decide to make a local law and we'd be here looking at that local law. But they haven't made that local law. It doesn't exist. There's no authority for HPD to decide in the first instance in this case to do what they are doing here, to make this distinction. Moreover, the law is clear that...
It speaks in the present tense of comply and not complied.
I'm sorry, Your Honor?
It's the regulation speaks in the present tense of comply and not, it doesn't say complied in the past tense.
Yes, and HPD is arguing, let us defer to our interpretation of that present tense as maybe letting us look backwards, but that has to be constrained, as Your Honors inquired when my adversary was arguing, by the enabling statute, which specifically states unless and until, which expressly permits curing of any unlawful conditions. And that's exactly what happened here. The owner cured all unlawful conditions, got a Department of Building Certificate of Occupancy, which is binding on all other agencies pursuant to the city charter and black letter law. And only after that was issued did they apply to HPD for review of the application. HPD simply lacks jurisdiction to look backwards. Moreover, much of what HPD argues is about inquiring into the conduct of the owner during the project. But New York City Charter 645B2 states that with respect to buildings and structures, the commissioner shall have the following powers and duties exclusively, subject to review only by the BSA, the Board of Standards and Appeals, to require that the construction or alteration of a building shall be in accordance with the provisions of law and rules and regulations in order that are applicable there too. So it is DOB and the Board of Standards of Appeals exclusive jurisdiction to police the conduct of a construction project, not HPD's retroactively.
Thank you. Does anyone have any questions? Thank you.
Thank you.
I think, Your Honor, just to pick back up, that it was in my brief that tax exemptions are in derogation of the taxpayer's responsibility. They're strictly construed against the one seeking the benefit.
We have no problem with strictly construing it, but you haven't told us what provision it is that we want to strictly construe. The provision you're talking about only is in the present tense. You haven't read us anything that gives you the discretion to go back in time to decide whether or not the exemption should be granted. So we're okay with strictly construing it, but you have to have something to strictly construe. What are you asking us to strictly?
We're strictly construing our regulation. That was the one that we drafted in this law, which is for that a building must comply with all applicable laws, including the enumerated ones, in order to qualify
at the time
for
of
the
application. That's what your law. That's what your regulation says. So if we apply that strictly, we look at whether or not they complied with all laws at the time of application. Why isn't that strictly construing it?
Because it means that, it drives a giant hole through what happened to the statute, because the statute requires that you have to comply. This is for safe and affordable, this is to make safe housing, and it's against state law. They're saying that basically a C of O is meaningless. They had tenants living there for 7 months before they completed the construction project. They didn't apply for a temporary certificate of occupancy, and they're asking the government to give them a tax abatement for many years for that.
Thank you.
Thank you.
Black versus City of New York.
May it please the court, Justin Bettis with the firm of Sacco and Felix on behalf of appellant Jarrell Black. Good afternoon, Your Honors. This case, as you know, is based in a gun buyback program by the New York City Police Department, wherein my client wanted to avail himself of the opportunity to turn in a gun in order to receive compensation. In doing so, he was arrested for criminal possession of that gun within the police department. Essentially, the police department created this program as for a community program to create a safer community, and they did not effectuate the program in a way that would not cause harm to this individual.
Can I ask you specifically a question about the false arrest and false imprisonment claims?
Yes.
So the judge in Supreme Court dismissed those causes of action based upon that they were not timely, basically based upon statute of limitations. Right. Now, the defendants never raised a statute of limitations defense in their answer to your complaint, right, as far as I could tell, and they never made a motion to dismiss on statute of limitations grounds. But at the trial level or at the motion level, you never, once they raised the untimeliness of the of those claims, you never said, oh, well, you waived that because you never raised that pursuant to the CPLR. Did you preserve that issue for appellate review? I mean, did you, in the motion court, ever say the statute of limitations cannot be raised by you defendants because you've already waived it? Did you ever say that?
Your Honor, I did not have this case at the trial court level. I am now just doing it at the appellate level, so I can't speak to that specifically. But was
it in the briefs?
In the papers and the briefs? Not to my knowledge, Your Honor. However, at this level,
is that a problem?
It does present somewhat of a problem, but again, I think that it was at the appellate level, it was never raised as an affirmative defense, nor expressly raised as a defense to eliminate those claims for false arrest and false imprisonment.
What should be the effect of that never being argued below? Why should we be addressing that argument at the appellate level when it was never addressed below to the court and to the city, who then could have responded in some way.
Correct. I mean, you are
Why
correct.
should we address it now?
Procedurally, Your Honor, I agree. And, you know, that
Wait,
is...
so let me be clear. When you say you agree,
I agree in terms of that it should have been raised at the trial level.
so it should have been raised, so therefore we should not consider it?
We can move on from those two claims, yes.
There's a preservation problem. There's a preservation problem.
Are you asking me, is it the preservation
Yeah.
problem? Yes.
Okay, you can go on with your argument.
Okay. With regard to the negligence claims in the here, those were also dismissed at the trial court level, and the Monell claim, the federal claim, was also dismissed for purposes of not being raised timely under the statute of limitations.
And did you really make any kind of substantive argument about those claims below?
At the trial court level, substantively, our argument was that in response to respondents' motion for summary judgment at the trial court level, we had in our opposition made responses to their basis for dismissal, and we also filed a cross motion to name the additional defendants as the officers themselves. So that was our response at the trial court level for those claims. With regard to the claims for malicious prosecution and abuse of process, it clearly meets all of the requirements at the trial court level. For malicious prosecution, there was a criminal action that was terminated. Our client was actually, the charges brought against him for criminal possession of a weapon and firearm were dismissed in September of 2018. And there was an absence of probable cause due to the mere fact that the intention of the gun buyback program was subverted by the police officers at the police department.
Does that equate to an absence of probable cause, or does that equate to a possible defense or some mitigation? Right, because if it's criminal possession of a weapon, he had a weapon in the precinct.
Right, but the intention of the argument is that the
I get the
intention of
intention. I understand you on that. But according to that program, the defendant was supposed to call ahead of time and let them know that he was coming in with this weapon. I think conceitedly he failed to do that. So there's a distinction between there being no probable cause for the arrest as opposed to there being probable cause and maybe you having a defense. Correct?
Understood. I believe that there was probable cause for the arrest, but at the time in the police precinct, when my client announced that he was there to participate in the gun buyback program, that the gun was kept in a concealed suitcase, separate from the ammunition. All of those totality of the circumstances in that instance demonstrate that he was there to participate in the program, whether or not he did comply with the specific protocol of the program that was communicated on the website.
Thank you very much.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Karen Wolf for the NYPD and the City of New York. I will be brief based on Your Honor's questions.
Counsel, it seems to me that you waived the defense of the statute of limitation. And now you're benefiting from the fact that plaintiff failed to raise that argument in lower court. Why should you prevail when you waived it?
Respectfully, Your Honor, I don't believe we did waive it. We did raise it.
Did you plead it? Did you plead it?
Not in our answer, but we did raise it on summary judgment.
After a note of issue was filed?
After the note of issue was
Is that timely?
It is, according to case law, it is timely. It's not fatal, and the cases are cited in our brief.
Case law in the first department?
Yes, Your Honor. In the first department, we cite Scholastic Inc. v. Pace Plumbing. It's a first department case from 2015. And then we cite a second department and a third department case. So across the departments, with no reference, I'm sorry, to the fourth department, but across the three departments, it's not fatal not to raise it in the answer. So the key distinction, if I may, Your Honor, is that the plaintiff had an opportunity to respond. We raised it in our motion papers for summary judgment. The plaintiff had the opportunity to address substantive arguments to the court.
Assume just for argument's sake that we believe that you raised it late and therefore it was waived. What effect should we give to the fact that plaintiff failed to raise that in the lower court?
I think the court could find that plaintiff failed, regardless of the court's determination of our position, the plaintiff waived. So the plaintiff did not raise it.
The plaintiff raised it below. You would have had an opportunity to respond with perhaps some alternative basis upon which to be given relief. The failure of the plaintiff.
Now I've gotten turned around. We did.
Plaintiff doesn't say below, you can't rely on this statute of limitations. You didn't plead it. You waived it. They don't say that. Had plaintiff said that, you would have had an opportunity to come back with some reason why you should be granted relief, notwithstanding.
Absolutely, and the lower court would have had the opportunity to rule on it, which would have allowed this court the benefit of the lower court.
But counsel, why, I mean, the CPLR is pretty clear on this issue. CPLR 3211E says, any objection or defense based upon a ground set forth in certain paragraphs, including paragraph 5, which concerns statute of limitations, is waived unless raised either by such motion or in the responsive pleading. 3211E doesn't say, but even if you waived it, you can bring it up later in a motion for summary judgment. So once it's waived, I don't really understand how you get to have a do-over. Can you, and as I recall the facts in Scholastic, they were not as straightforward as they are here.
With respect, it's not a do-over in the sense that...
Well, it's another attempt to raise the statute of limitations, even though you violated the direction of 3211 that any statute of limitations defense has to be raised either by a motion to dismiss or in the responsive pleading, or it is waived. It doesn't say waived until you do something else, right?
Absolutely, but it's not a do-over in the sense that we're taking a second bite at this apple.
Of course you are. Why? You got a bite, you chose not to take it, and now you're trying again. Why isn't that a second bite?
Because it was never affirmative, it was never determined by the court. So
but the CPLR doesn't require that. They don't say, if you don't raise it, it's waived, but you could, and since you never got it decided, you can come back. It very clearly doesn't say that.
I think as that CPLR provision has been interpreted by the courts,
by this court. I'm not talking about the second department. I know that other departments interpret that differently.
Well, and I think the second, then we'll focus on Scholastic and also on the fact that there was no prejudice to the plaintiff because the plaintiff had the opportunity and chose not to make that argument before the trial court. That notwithstanding, as we argue in our papers, the plaintiff also fails to make out the causes of action for false imprisonment and false arrest.
Thank you.
Thank you, Your Honors.
Just to conclude, Your Honors, with regard to the NID and IID claims, those claims are not duplicative. They are separate in and of themselves. And the standard which it has to meet is shocking the conscience. And again, I think if we look at the cases very simply is that my client was there to participate in the gun buyback program and to then be arrested in the precinct for having possession of a gun when one would have to physically have possession of the gun to physically turn it in due to participation in the program, it does not meet, it would be shocking, it'd be unconscionable that someone would then be arrested. And my client was then incarcerated at Rikers Island for 6 days before going on to 8 months of litigation before ultimately be found, having the charges dismissed against him. So I think that we have to kind of, I understand this case is very technical in certain aspects in terms of waiver of certain claims. However, we need to look at all of the claims individually that the lower court erred on in dismissing this claim in consideration of, overturning the lower court.
Thank you very much.
Thank you, Your Honor.
And our last case on the calendar today is People versus Cerillo.
Good afternoon, Your Honors. May it please the Court. Cara Labini from the Center for Appellate Litigation on behalf of Mr. Zorrilla. The pattern instructions that the lower court, acting as the fact finder, charged itself with explicitly require that to convict the defendant of course of sexual conduct, it must be proven beyond a reasonable doubt that, quote, in the county of New York, the defendant engaged in 2 or more acts of sexual conduct. But the prosecution, there's no dispute, only alleged that there was only 1 New York act. So as to that charge, the evidence was legally insufficient, and this court must vacate and dismiss. The pretrial motion to dismiss alerted the lower court to this problem. It argued the prosecution only alleges 1 New York act, and the CJI requires 2. There is a problem, and the indictment is insufficient. The lower court ruled that contrary to the CJI, course of sexual conduct requires only 1 New York act. But the charge to the fact finder says what it says. The prosecution contends that somehow, I believe it contends that somehow the defense waived this claim at the charge conference. That's incorrect for at least 2 reasons. 1, the defense cannot waive jurisdiction. McLaughlin, Moore, Greenberg say that. Second, the charge conference was not about the course of sexual conduct charge. It was about the 2020 geographic jurisdiction charge. The court at that time acknowledged it had not even read the course of sexual conduct charge. So as
Anyhow, isn't 1 act in New York enough? The nature of the offense is a continuing offense. So whether it starts in New Jersey or Connecticut or wherever, if this continuing offense concludes in New York and there's an act in New York, why shouldn't that be enough to give New York jurisdiction?
Well, the CJI says what it says. So Your Honor's question is whether the CJI charge is correct. It is correct. There are 2 or more acts required because there's only 1 actus reus element. It cannot be that there are multiple actus reus elements. And if this was a jury case and the jury was charged under 2020 with determining whether the evidence
Language about New York, though, is not in the penal law itself, right? It's just, the penal law refers to 2 or more acts of sexual conduct. It doesn't say 2 or more sexual acts of
That's right, the
sexual conduct
jurisdictional
in New York. So, I mean, really, the focus should be on the penal law, and what the penal law does not require, shouldn't it?
The penal law is to 2020 geographic jurisdiction. The penal law never includes a jurisdictional element. Jurisdiction must always be proved by the prosecution beyond a reasonable doubt under 2021A, which was raised in this case. When the defense...
No, but you're talking about the jury charge, you're not talking about the relevant statute.
Well, the arguments somewhat bleed into one another. As to the charge that was given to the fact finder, which in this case was the court, the charge required 2 or more acts, and Your Honor I'm sure has read the CJI. The CJI just says 2 or more acts of sexual conduct in the county of New York. So as to legal insufficiency as to the charge, there's that argument. The argument that in general, as under 2020, that the New York conduct is sufficient to establish an element of the offense, that's a somewhat different analysis. And that's where we talk about whether the New York conduct is sufficient to establish an element, the actus reus of the crime. If this was a jury case, and the jury was charged with 2020 as the defense requested, the jury might have then asked, well, Your Honor, what's an element? How do we figure out whether the New York conduct is sufficient to establish an element of the offense? The court would have had to then look at the CJI to determine the elements of the offense and read the CJI of course of sexual conduct.
Or not.
Well, the
Right?
court could have...
The CJI is instructive, it's not mandatory, right?
Sure, but the court would have then relied on, there's no case law or anything else on this topic. It's an issue of first impression. So the court certainly could have instructed something else, but
So
the
in light of-
CJI is the most obvious
In light of what I
evidence.
think most would agree that this is a continuing crime, why does it make sense, or why is it required that both acts, right? Because you're referring to it as a single actus reus, and I guess you could argue that, right? But that single actus reus has 2 independent acts, right? And they don't have to happen on the same day. They're definitely not going to happen on the same occasion. It's envisioned that one will happen at one time and the other will happen at a separate time.
Mhm.
So what's the requirement that they both happen in New York County?
Mhm. Well, I think that in this particular case where course of sexual conduct is used as the underlying offense of the predatory sexual assault, that reading would do away completely with using rape as an underlying offense in the cases of alleging multiple rapes. rape is the proper underlying offense when there's only one act alleged or multiple rapes. When it's a course of conduct which occurs elsewhere as well as in New York,
It's multiple rapes on multiple dates, isn't it?
yes, but only one in New York.
I get that. But why are you requiring all of them to be in New York?
Because
If it's in light of the fact that it's a continuing crime.
Sure. I mean, I think the best evidence that we have that our reading is correct is the CJI charge. I understand that that's not mandatory, but where the court is going to be ruling on this topic, you know, as I said to Justice Friedman, the question is whether the CJI is correct. I'd like to reserve the rest of my time to speak about the geographic jurisdiction charge 2020. Thank you.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors.
Counsel, your adversary says that the court charged itself the way that it did, pursuant to the CJI, which requires that both acts have happened in New York County. Is that fatal?
Well, first of all, the CJI is not the law, and the court.
Well, that's true, but it charged itself, right? It had it been a jury that instead of a bench trial, it's a different dynamic, I would imagine.
We don't really have to guess at this question because during the charge conference, the defense counsel said that so long as it's clear that at least one of the acts must be in New York, and the judge said, I think it has to. And then the judge added, if this were a jury trial and the jury had a question about that the judge would tell them that you have to find at least one incident of sexual conduct happened in New York County. And defense counsel said, understood. So when counsel raised the question of the CJI charge and the question of what the judge would be charging himself, this was hashed out and it was made explicit that the requirement, as the judge saw it and as counsel understood, was that one act had to have occurred in New York County.
Counsel, that may have been the intention, but if the ultimate charge read that both have to be in New York County, what effect does that have?
Well, I think I would come back to the point that the CJI is not the law, and there are instances in which the court needs to vary from the CJI. And I would say that in this particular, with respect to this particular statute, I can't dispute what the CJI says. It lumps the two acts as one element. But as I explained in my brief, the question of how to divide a particular law into elements is it's not always so clear, and this particular crime, of course, of conduct of sexual conduct against a child doesn't have to be divided into three elements, and in fact, in certain instances, it would seem that it would have to be divided into more than three elements because, as Your Honor just noted in questioning my adversary, that it requires two separate acts. And not only do those two separate acts, it's not necessary that they're on the same date. In fact, they can't be on the same date. They have to be at least 3 months apart for this crime. And I would also note that in this particular crime, there are provisions that you have to have certain types of sexual conduct. And there has to be a finding that at least one of those acts of sexual conduct is vaginal sexual conduct or oral sexual conduct or several other types of conduct. And then the second type of conduct can be sexual contact without rising to the level of one of those other things. And so in this particular case, there was no issue about whether the type of sexual conduct fit the definition of the crime, but it would be easy to imagine some other case in which there is one act that fits that definition, but the second act is sexual contact, not rising to that that other level of vaginal sexual contact or so forth. And in that particular type of case, if you had a jury trial or even a bench trial, the charge would have to set forth as a separate element that the jury or the fact finder would have to find that one of those acts met that higher threshold. So you'd have to break it up into a separate element. And that's exactly what happened here. In this case, it wasn't the way that the defendant committed the crime that had to be separated. It was the where the defendant committed the crime that had to be separated. And everybody understood that, as evidenced by the charge conference, that there had to be a finding that that the New York County Act was committed, was proven beyond a reasonable doubt, because otherwise there wouldn't be jurisdiction. And I would just note that, it makes sense if you consider the trial record as a whole that defense counsel would have taken that position, because counsel aimed particular arguments at the credibility of that particular act and tried to convince the judge that that particular act wasn't proven, as opposed to the New Jersey acts. And maybe the New Jersey acts were proven, but that New York act was not. And so as an overall strategy, it made some sense, but it recognized that it was really undeniable that the one act in New York was enough. And so I would say that if the court wants to examine this as a question of whether one element was proven in New York, then that would be a basis to find that jurisdiction was established. Or, as the court has also suggested, if the court wants to say that this was an ongoing course of conduct, it was a continuing offense, it's right there in the name of the statute, course of conduct, of sexual conduct against a child, that it was sufficient that part of that course of conduct occurred in New York County for jurisdiction purposes.
Respondent decontextualizes the charge conference in problematic ways. The defense wasn't telling the court to ignore the jurisdictional element of the CJI. It was merely referring to the pretrial motion to dismiss, which was denied, and saying the law of the case is that, problematically, with respect to the CJI, the law of the case is that only one act had to have occurred in New York. And also problematically, the charge conference was not about the course of sexual conduct charge. The court admitted that it had not even looked at that time. The charge conference was about whether to charge 2020, the charge for geographic jurisdiction. The denial of that charge was separate reversible error under this court's decision in Thomas, when requested, when jurisdiction is an issue, that charge must be given. The lower court denied it, finding that it was duplicative of the jurisdictional element in the CJI for course of sexual conduct. So not only did it improperly deny it, it also found that it was already covered by the course of sexual conduct charge. But that element, it according to respondents' view, essentially crossed out and replaced with one or more acts rather than two or more acts.
Thank you.
Thank you. Thank you, Your Honors.